largest number of patent filings in the world for soccer. Interestingly enough, Adidas research and development team continues to do work on the aerodynamics and physical properties of footballs to ensure that the balls meet the standards that are required. Now, you would imagine that this would involve a quadrennial exercise every World Cup. So everyone is always waiting to see what is the latest, what is the next best thing that will come out. Having said all that, what are intellectual property rights? I am pretty sure that a lot of you here with us are familiar with the Trinbago Knight Riders logo. This logo has actually been registered with the Intellectual Property Office for a variety of goods and services. Intellectual property rights, therefore, are those exclusive rights which are given to the owner of a creation or an invention. Now, in the interest of time, we are going to hone in on the intellectual property rights that are involved in the sporting industry. So we have copyright and neighboring rights, and we also have industrial property rights. In particular, we will be focusing on trademarks, patents, and industrial designs. Copyright. You may have heard the term before. Well, copyright is the right that subsists in original literary, artistic, dramatic works. Your copyright will subsist in the sporting industry from items such as memoirs, as you will be familiar with the name Sachin Tendulkar. We have an image of his memoir published on the extreme right here of this slide. And interesting enough, pursuant to our Copyright Act, computer programs are protected under the law of copyright. So in cricket, you may have heard of the Hawkeye technology, which is used to track the trajectory of a ball. It actually generates statistics regarding the most likely path that the ball will follow. Long ago, back in the 1800s, the rules pertaining to lawn tennis were protected by copyright. However, when the works or the protection for the duration of the works, or the rules rather, fell into public domain, everyone adopted it and started playing. So lawn tennis continues with minor amendments to the rules. Neighboring rights. You may have heard about broadcasting and broadcasting rights for sporting events. Some of the major players involved in broadcasting rights include ESPN, Fox Soccer, and Sky Sports. These are the rights which are essentially given to those which perform or make or produce or broadcast a copyrighted work. Now, interestingly enough, research has revealed that Facebook has been given the exclusive rights to broadcast the ICC in the next couple of years. And this was due, sorry, I'm getting some feedback. The growth in Facebook being granted the rights was due to the growth in consumer demand for the digital environment to be able to view matches and to view events. And ICC intends to expand the viewers and to expand the generations who wish to view sporting events and cricket in particular. Another industrial property right which we would like to look at is patents or patents, depending on which you prefer to pronounce. So patents essentially protect inventions and they are new solutions to existing problems. So you have examples ranging from the pharmaceutical and chemical industries to mechanical and electrical advancements. In the sporting industry, you may find patents existing in breathable shoes, breathable clothing, for example, or foam technology. I have actually included a cross-section of the bail that is used in cricket. You may have heard of what is known as the zinc bail, which lights up on impact. This was actually developed by an Australian company to, in accordance with the definition of a patent, solve the existing problem of determining whether the stump was dislodged from the top. Interestingly enough, results can be generated within 1/1000th of a second. So you could imagine that that is something that is done pretty fast. If you look at the diagram here, you would see parts 44 and 48. Those parts actually generate the sensors, or actually where sensors are located to determine the impact. This is an image of the bale lit up. Another industrial property right which may be of interest to you is industrial designs. These designs, or this right, specifically protects the ornamental aspect or the aesthetics of an article. They must be novel in order to attract protection, and your designs may be two-dimensional or three-dimensional. So I would have indicated to you the shape of the football before and explained that Adidas is constantly doing research and development to ensure that they have the latest in the sporting industry or in the sporting markets. Now, we all know who this famous guy is, Mr. Chris Gayle. So, in addition to intellectual property rights, athletes, athletic bodies, they also benefit not just on the field, but off this field through sponsorships, being brand ambassadors, and through any other agreements which they may enter into with companies. So before I pass you over to my colleague, Ms. Sarah Jagisa Singh, who will continue on trademarks and branding, I would like to share with you a little video with Mr. Gill. Please enjoy. Okay.
Hi, I'm not hearing the audio on the video.
Hi, good day. We restart the video. Please let us know if you're hearing it.
No, Lorinda, there's still no volume.
We do apologize for the audio. We're apparently having some technical difficulty, but we will share the presentation with you all after.
Sure.
Hi, good morning. Thank you, Lorinda. So let's discuss the concept of a brand. What is a brand? Could you hold, please? The computer is ticking a bit. Hi, sorry about that. So let's talk about the concept of a brand. A brand represents your business and your reputation in the public eye. A brand is a promise made and a promise kept. Now, there are different types of brands. You have personal branding, you have product branding, country branding, nation branding, and celebrity brand. Hold, please. Clem, call. Hi, everyone. I'm sorry about that. We were just having some technical difficulties. Trademarks, on the other hand, gives protection over the use of logos, names, slogans, and symbols. Trademarks are valuable assets. They build trust, confidence, and loyalty in a product, and if successful, represents a promise. So as you can see on my left, you have Nike, famous swoosh, Mark, and Gatorade. They are both currently registered at the TTIPO. So what is the relationship between trademarks and branding? A lot of persons confuse the both and think they are the same. However, they carry different functions. So while your brand represents your reputation and business in the public eye, a trademark legally protects those aspects of your brand that are unique and specific to your company. So as you can see at the bottom there, Puma is a trademark of Puma SE, and the R singles that aspect, the legal aspects of branding. This is where intellectual property comes in. The role of brands in sporting events. Sports stars and event organizers usually register their trademarks not because they wish to provide branded goods, but to also enable them to license the mark for others to use. By protecting a brand or trademark, organizers of sports events can ensure that the value and integrity of the events are maintained, maximize commercial revenue from sponsorship, merchandising, and licensing agreements, inspire confidence among consumers that the product associated with the sporting brand is authentic. Naming rights at stadiums. A naming rights agreement is a financial agreement under which a corporation or individual purchases the right to name a stadium in exchange for a financial payment. And this could be for a specific period of time. It could be 10 years, it can be 20 years. This has become a simple and effective way for clubs to generate a new stream of revenue in an increasingly competitive market. So, for example, Toronto-based ownership group Maple Leaf Sports and Entertainment has agreed to a 20-year stadium naming rights deal with Scotiabank, worth a reported US 639 million US dollars. The importance of sponsorship. Sponsorship is still seen by many companies as a worthwhile investment in order to heighten public awareness of their corporate identity and enhance their image generally. So as you can see, Trinbago, there's a snapshot of Trinbago's Night Riders. The principal sponsor of the Trinbago Night Riders are Mobile Premier League. Other sponsors include Carib, RBC, and KFC, just to name a few. So just as companies can register their brand as intellectual property rights and trademarks, so too can sporting celebrities. They can register their nicknames, their slogans, signatures, for which they are well known for. So, I mean, we may all know this image. This is a famous image of Usain Bolt's lightning bolt pose. And this is actually a registered trademark at the TTIPO. This is also another snapshot of his mark, his name, registered at the Intellectual Property Office. And as you can see, the status, which states registered, the sign type, name only, and his name, which is the actual trademark. And it's registered under 5 classes of goods and services. Class 9, eyewear, class 14, clocks and watches, 18, leather, class 25, clothing, footwear, and headgear, and class 28, games. A brand is embedded in the athlete's personality. However, the brand can become diluted if the image is negative. This is not the case with Andrew Lewis, as he is passionate about giving back to Trinidad and Tobago and has worked with the young people, including sailing programs across the country. He raises awareness about dyslexia and ADD. He has established the Andrew Lewis Sailing Foundation, which is aimed at creating opportunities for young underprivileged people to develop their untapped potential. And now he's the brand ambassador for Tattle, CEMEX TCL, for Trinidad. This is as a result of successful personal branding. National sporting bodies. Currently, there are several national sporting bodies in Trinidad and Tobago. IP offers avenues for broadcasting and sponsorship for organizers of sporting events, athletes, and the local communities. For example, sports sponsorship deals are underpinned by trademarks. In recognition of its power as a marketing platform, Companies in many sectors are tuned to sports to build awareness of their products among consumers and drive sales. So, for example, wearing companies' t-shirts, logos, having banners included in the event, sponsorship of prizes. Athletes get to put themselves out there, and in turn, sponsors can create brand awareness. So this is a case study on Hoyt. Intellectual property plays a vital role in the success of Hoyt Inc., as they're known as an innovative company. Every year they keep changing their product line, and it's not because the product is faulty. It's because they're continuously doing research and development on their product line to meet the needs of the archers, to improve the velocity of the bow itself. So the company recognizes its valuable and tangible assets and sought to protect it. So every part of the bow is registered as a patent. Every piece of new equipment that is added onto the bow, it has also an industrial design, and Hoyt is the brand itself that is registered as a trademark. This is an actual snapshot of the Madrid Protocol, and Hoyt has actually used the Madrid Protocol to successfully register the trademark internationally through one application, one language, one fee. And this is actually this snapshot from Hoyt. You can see the name of the mark and the different jurisdictions that they are registered under. Also, they are registered in class 25 and 28, sports caps and hats, archery bows, archery equipment. So I now hand you over to my colleague who will further discuss the Madrid Protocol, Ms. Anita Baiju.
Thank you, Sarah. So now we will be going into the Madrid Protocol. So the question is, what is the Madrid Protocol? So my colleagues has been talking about protection at the national level, but I'll be looking at the Madrid Protocol, which is an international route where one can protect their mark. So what is the Madrid Protocol? It is an international filing system which allows trademark holders such as sporting bodies, protection of their trademark in several countries by filing a single application. So with the Madrid Protocol, you have the single application where you can designate the different jurisdictions that you want protection, and you can do so through the Intellectual Property Office. Trinidad and Tobago is party to this treaty. All right, we deposited the instrument of accession with WIPO on October 12, 2020. As at January 12, 2021, there are 107 contracting parties to the Madrid Protocol, covering 123 countries worldwide. And this treaty came into effect on January 12, 2021. So this here is just a visual in terms of what will happen in terms of if you considering to file through the Madrid Protocol. So you would, so let's say Trinidad is here, I hope you can see the cursor here, right? You would fill the international application, it will be forwarded to WIPO, which is a specialized agency of the United Nations. And once they have processed the international application, then it is basically reported to the different jurisdiction that, you know, hey, we've been selected and it is subject to an international application. So what are the main features of this protocol, of this treaty? First, we have language. So you have the option of filing in Spanish, French, or English. So in this jurisdiction, Trinidad and Tobago, we have opted for English. The examination time period is 18 months. So this is the period in which you can give a first response in terms of the whether the mark is acceptable, whether it is there are grounds to refuse. Now, if, however, there has been no response within that 18 months, there is an automatic acceptance of the mark. So that is why this 18 months is very crucial to the TTIPO, that we examine the mark within that particular period. We have the fees, basic fees and individual fees. The membership extends to nations and IGUs. So when we say IGUs, we're talking about like the EU, we're talking about ORP, etc. The period of protection for a trademark, it's 10 years. I'm sure my colleague would have mentioned that when they were going through trademark, and it is renewable indefinitely. And finally, the last feature is basic mark. What do I mean by that? In order to file an international application, the holder must have a pending application or a registration at the TTIPO. Right, so I mentioned about the IGUs previously. So these are the regional routes. So if it is that you select the EU on the international application, you would have protection on all the countries under the EU. Then we have OAPI, and then there's also this other regional route, the Benelux office. So in this jurisdiction, you would have protection in Belgium, Netherlands, and Luxembourg. Moving along swiftly, what or who are the main actors of the Madrid system? We have the Office of Origin. So the Office of Origin would be where you would have your basic mark and your filing to the office. So Trinidad and Tobago, TTIPO, we will function as the Office of Origin. Then we have the IB, being the World Intellectual Property Organization, and finally the DCP. Two roles of the IPO. So as the TTIPO, we have a dual function, right? So we operate as an office of origin, and we also operate as an office of a DCP. So as an office of origin, we will assist local companies, individuals, agents, as the case may be, to file the international application. So we will assist whoever decides to file through the Madrid in terms of accessing the relevant tools, filling out the application, etc. Then we will perform a certification. So this certification is essentially ensuring that the information of the national the basic mark corresponds with the information on the international application. And we respond to irregularities regarding the international application, perhaps that there was a wrong class on the application, they did not fill in terms of like they selected color and they didn't put a description of the color claim on the international application. So those are some of the things that we will be responding to. As an office of a DCP, meaning a designated contracting party, we would receive the designations from the foreign trademark owners that, hey, we've been selected on the international application and we need to examine this international application. And upon receiving that application, we perform a substantive examination to determine the scope of protection based on our national laws. So here we have a visual in terms of what happens at the Office of Origin. So we receive the application, we perform formalities of the application, ensuring that all the information is present in the application. We double check the classification, and then we perform the certification, ensuring that information from the basic application corresponds with the international application. Then we forward it to the IB. So the IB receives the application, they conduct the formalities and classification. So this basically double checking the information. They record it in the international register and publish it in the Gazette, which is their official publication. Then they proceed to notify each DCP in terms of they've been selected, and whatever decision happens at the DCP, they in turn needs to inform the IB. Processing at the DCP. So say, for instance, we've been notified that we've been selected on the international application. We would perform a search, and then it goes to the examiner. They can accept, they can refuse, whatever the decision is, they have to inform the IB of that particular decision. So what are the benefits of using this protocol? Well, it's an easier management of the applicant's brand portfolio through a centralized system. So instead of having to individually check up on these applications, the holder can do so through the Madrid Protocol, because the Madrid Protocol has a number of online tools which afford you that benefits, and we would see some of those tools later on. It is also a very convenient and cost-effective system. So we have one filing fee. It's a very convenient. Why convenient? Because you are just simply filing one application and selecting all the countries that you want protection, as opposed to individually filing those applications in each jurisdiction. And finally, it offers a route to global branding for entrepreneurs. So here we have filing an international application under the Madrid Protocol. So in order to do so, let's say an athlete or any interested person wants to file an application through the Madrid Protocol, they would need to have a national application or registration. So I just have a picture here of Kishan Walcott. Why? Because if he wants, he can file through the Madrid Protocol. Why? Because he has a national registration at the TTIPO. Right, so he has registered at the office and he has done so in a number of classes relating to let's say clothing and financial management, education services. So if he decides or wants to file through the Madrid Protocol, he can do so because he has a national registration at the office. And just enforce this, we have some examples of international athletes as well. So we have Lewis Hamilton has also used the Madrid system, right? And here we have the information through WIPO Global Brands. Now this is a database that is accessible to anyone. So you can actually look up and you would see that he has filed through the Madrid Protocol and he has protection. If you look down here, designation under the Madrid Protocol in Australia, in China, Japan, etc. All right. Another example, we have Tiger Woods. He has also used the Madrid Protocol and he has protection in Australia, Singapore, in the EU. So this is just to show that you can use the Madrid Protocol to protect your brands in these foreign markets. Okay, so you protect in your home country, but you also protect in the foreign markets as well. So here I was talking about some online tools that will assist you in this process. So you can file the application through, we have the Madrid application assistant. We have the links here, so you can always have it for future use. Then we have the member profile database. So this link affords you that information in other jurisdictions in terms of their procedures, what's the requirement to file in that particular jurisdiction. We have the Madrid Goods and Services Manager. This will assist you in terms of the goods or services, classifying them into a particular class. We have the fee calculator. So the fee calculator will assist you in terms of calculating the cost to file this international application. So you would have an idea beforehand how much it will cost you to file this international application. Finally, these last two tools here, the Madrid Monitor, the Madrid Portfolio Manager, will assist you to track the status of the application and to perform future transaction in terms of paying for the application, if you have to do a renewal, etc. Okay. Here we have a snip of our website, the TTIPO's website, where you can find further information on the Madrid Protocol. So you would go to our website, ipo.gov.tt, and you can click on online services. It will take you to a variety of options. You click on the WIPO services, and then you have Madrid Protocol. You can also call the office, and if it is you want to speak to one of the staff of the Madrid processing unit, you can do so. That is also available as well. But we have tons of information on our website regarding the Madrid Protocol. So to conclude, what are the main points to remember? Register your IP, protect your IP. My colleague would have talked about a product having multiple layers of intellectual property. So they may have patents, they may have trademark, they may have industrial design. So please register your IP, exploit your IP. So this would be the one instance where exploitation is seen in a positive light. So you commercially exploit your IP, whether it's through licensing agreements, sponsorship, merchandises, etc. And finally, the Madrid Protocol is here, so please utilize the system in order to protect your brands on the international markets. So here we have our contact information, and if you have any questions, we will await for them. Right, so while we're waiting for the questions, I have my colleague here who will show you or have a live demonstration.
Hi, good morning and good afternoon again. I actually have the physical bow, the compound bow with me, and it's not the traditional recurve bow that Robin Hood would have shot. So this is a compound bow and it's way more advanced than the traditional recurve bow. And the reason for that is through intellectual property. This bow actually has three forms of intellectual property rights that we can identify: the industrial design of the bow, and it's called a compound bow. So it has three strings as opposed to the one string, and this is called the limbs and the riser. Also, these are the cams. This would be the patent aspect of intellectual property, as well as this is the arrow, RRS, and the trademark, it's Hoyt and it's stated on the bow. So as you can see, this is a sports equipment and it's a compound bow and it's used in the Olympics. And this actually has three forms of intellectual property rights. So I now welcome your questions and thank you for viewing us.
Hi, this is Regan Ascarali, Controller of Intellectual Property. I really want to thank the participants for listening to our team of experts from the Madrid Protocol Processing Unit. And we really look forward to working with your key stakeholders in the sporting ecosystem to utilize this protocol. As we are available online, you can file for your trademark online. There are training videos available at IPO Trinidad on our YouTube page that takes you through very succinctly the filing process and the payment process. And of course, we encourage you to ask your questions and email it directly to our Madrid Protocol Processing Unit. So getting your branding for your NGBs, for the NSOs up and running. We are here as your partners with Sport TT in this regard. And there's a nice question from Rebecca, Miss Bola. It's not a silly question. There is no silly question. Can our developmental programs be registered with copyright? With copyright, of course, it must be original literary or dramatic or artistic work. If there are unique aspects of your business plan, for instance, that can be protected by copyright. So there are four ways in which you can assert your copyright. One is called the poor man's copyright, where you can register, post back your developmental plan to yourself and leave it unopened, because that stamp date will be used if anybody had tried to copy it, and that could be used for evidence. You can also have a statutory declaration asserting copyright in that unique literary work of the developmental program, and that is done by way of statutory declaration attaching that physical written work. WIPO as well has a service called WIPO Proof, which is directly on our website under online services, which gives you an evidential certificate for uploading your plan. They do not keep it. They just upload and then they give you back that particularly evidential certificate. So there are several ways in which you can assert copyright. And of course, the internationally registered, recognized symbol of the C in a circle with the name of the NSB or the CSO, all rights reserved, and the year in which the developmental program in that literary work was created. So that is just some information on copyright. A business selling sports products, clothing, drinks, or snacks can be registered with the IPO. By all means, businesses register their products with the IPO. However, if it is not your sporting product, your clothes, etc., they would be owned by other brand owners. So if you have come up with your own intellectual property, by all means, speak to us and you can get them registered. If you come up with your unique design, as Anelia would have spoken about and Sarah, you can actually look to have that unique design registered as well. And a great example is the chubby bottle that has been protected here locally as an industrial design. Major fashion brands are also registered in Trinidad and Tobago from our local fashionistas. So the key now is to get the sporting ecosystem more involved in actively registering their brands, their products that you come up with to support that ecosystem. Any further questions? Well, thank you very much. I think, we're very grateful for the time given to us by Sport TT. And as I've said, we've left the materials at the Center of Excellence for you. And it's at the Aquatic Center, but I call it a Center of Sporting Excellence. And, and it's here for you to avail yourselves. Thank you very much.